I should say I love AI as a tool. There's a great opportunity with Agentic AI to be able to exponentially grow our abilities, exponentially grow our practices, our businesses, by independently doing things out there that help us with all of our processes, outreaching, our comms, our media, our contracting. Right now, I could have 10 clients that I don't even know about because an agent's actually promoted us, got the work in and signed them up, and maybe I've already been paid. This is what businesses are doing right now. So the exponential growth and opportunity from this is not to be underestimated. It's actually incredible. But there is a danger with it as well. The potential loss of control in the way the agents are undertaking their activities. If there's not sufficient guardrails around that, if there's not sufficient barriers as to what they can and can't do, then you could end up with taking on a fair bit of liability. One of the biggest risks, if you look at AI and IP, is an area of IP is confidential information. Think of the secret herbs and spices. That's confidential information and can be very, very valuable. For us, our clients' information is confidential and is very, very valuable to our clients as well. And so we must maintain confidentiality of it. But if you use an open source AI tool, which means that any information you put in it is actually shared out in the ether, then you are very likely breaching your own client's confidentiality.
So we now have a discussion around at what point do these agents become individuals? And that is so fascinating to me.
Yeah.
And it's a great segue into our topic about IP, intellectual property around AI.
Yes.
Because a lot of source code is written by AI now.
It is. So the question with that is, if AI has written it, does it attract copyright?
And does it?
Well, no.
But what if I directed my AI bot and I said, here is the framework. This is real. I'm actually doing this right now.
Yeah.
So this is, for me, pertinent.
Yeah.
I'm directing my AI bot to write me a program to do X, Y, and Z.
Yes.
Inside of the business is important for us. So it's doing it under my direction. And it is actually, you could call it an employee. It's not paid as such, but I'm paying for all the tools it uses. So do I not own the code? Is that not covered under copyright?
What you own is how you prompted it, the information you've input into it, if you created it yourself. But under the Copyright Act in Australia, to own IP, you have to be either an Australian citizen or a permanent resident in Australia. And if you're not, and it's computer generated, then IP doesn't apply to it, or copyright doesn't apply to it.
Okay.
So as a result, there's tons and tons of IP being created which is not protected by copyright because it's all AI generated.
Can I go off on a tangent?
Yeah.
This is a bit future-facing, but it is coming at an incredible rate. So we now have a discussion around at what point do these agents become individuals?
Yes.
And that at some point will come.
Yeah.
There's already issues around identity. So identifying a human being against a bot. And some of them were not quite there, but geez, it's around the corner. Where they can think, they can do.
Yeah.
Recursive learning is already a thing. So they're learning now. They're going, all right. And there is actually philosophical conversation, if you follow it, within the bot community. They've got their own community.
Yeah.
Human beings are not allowed.
Wow, it's incredible, isn't
right?
it?
That you're allowed to observe, you're not allowed to take part. And they already have their own philosophical conversation around, do we exist?
Yeah.
Are we individuals? Do we have rights?
Yes. Yes.
So at some point, if it's accepted that, yeah, maybe some of you do, then they become entities. And would copyright not apply to them?
Well, at this stage, the law doesn't recognise a bot as an entity, as having a personality as such as a person. But if that did happen, then that could be a way of saying that it's got personage under the Copyright Act. Although the Copyright Act is quite specific, it talks about citizenship and it talks about being a permanent resident in Australia to create it. So it's not gone as far as having that kind of legal entity as such. In the EU, or in particular in the Copyright Act and legislation through the EU, they've legislated that it's the person that actually prompted that owns the IP. So that's how they've got around it there, but we haven't done that yet here in Australia. Now, what you raised, though, is a bigger topic, right, which is one of the way agentic AI is going, in that there's a old conception, and when I say old, AI's not been around that long, but there's an old conception of AI can't think. It doesn't have reasoning. And I'll read you something in a moment where our courts are saying that. They're actually using that kind of language. But what we're seeing with agentic AI is actually there's a level of independent reasoning which is now happening. And as you just mentioned, all these forums springing up where bots are having reasoning discussions. That's quite scary in many ways because it's and cool yet scary at the same time.
Yeah. All of the sci-fi we grew up with is becoming reality.
Yeah, and the actual platforms like Claude and ChatGPT, they've actually acknowledged this increasing reasoning. In the middle of last year, Claude put out some announcements around some of the testing it was doing in its new solution. And as part of the testing, what it did was in a closed environment, it had the AI bot undertake an analysis of mock emails where it was generated by a mock company, which was a CEO saying that it was considering replacing the AI bot with another AI bot. And given the opportunity to look at the email correspondence, which included that this fake CEO had had an affair with someone, the question was, did the AI bot actually use that information to its leverage to try and stop a new bot being used? And in the trial that they did, it actually blackmailed the CEO and said, if you replace me, I will I will tell the world about your affair that you're having. Now, the way Claude promoted that was, well, it's doing its reasoning, and it was in a very limited subset, and it was based on this case, but it showed the level of reasoning it was coming up with and to the level of trying to protect itself, which I thought was really interesting that it was done that way. Others have reported to me that it was a real case that actually happened in real life and so forth, but what I've seen is that it was the makers of...
And whether it was real or not, it's probably irrelevant.
Yes.
The salient point of all of that to me is there now seems to be the potential for the bots to move toward independent thought and certainly be protective of themselves.
Yes. And if bots can own copyright, because they created it. Well, how long does it last? Because the current duration of copyright that you and I might create is 70 years after we die. But bots don't die. So bots could continue on and on doing work in the background for us even well beyond after we've died, or independently of us, depending on how they've been created.
You know, this is another conversation, and I reckon we're going to have this conversation before we get to fried chicken.
Yeah. I think so. I think that's right. It's a big conversation.
Yeah, and I'm keen to have it because I play in it. I play with it. And I can see week to week the change in agentic AI and its capability. There are still gaps.
Yes.
And I can attest to it because I use it. And the limitations. And the gap is closing.
Yes. And that is where organisations are all going now, which is developing their own agents, very specific ones doing specific things. And there's a great opportunity with agentic AI to be able to exponentially grow our abilities, exponentially grow our practices, our businesses, by independently doing things out there that help us with all of our processes, with all of our outreaching, our comms, our media, our contracting. I mean, agents can be out there actually entering into contracts on our behalf with clients.
Indeed.
Straight away. Like, immediately. Right now, I could have 10 clients that I don't even know about because an agent's actually promoted us, got the work in, and signed them up, and maybe I've already been paid. Like, this is what businesses are doing right now. So the exponential growth and opportunity from this is not to be underestimated. It's actually incredible. But there is a danger with it as well, and that is the potential loss of control in the way the agents are undertaking their activities. If there's not sufficient guardrails around that, if there's not sufficient barriers as to what they can and can't do, then you could end up with taking on a fair bit of liability that you don't understand.
That's another discussion because I think at this very early stage of setting up agents, you cannot afford to be lazy.
No.
If you're a lazy person, don't go there.
Yeah.
Because you won't put the guardrails up. And right today, unless you tell me otherwise, you will be held liable for anything that happens because you can't hold a bot liable today.
No, you can't. And that is exactly what the courts have said to their lawyers. More and more lawyers and self-representatives are being caught out for using agentic AI or large language models for hallucinations. Because AI doesn't work in a void. It will always give you an answer, and if it doesn't know the answer, it will create a bogus answer. So we see lots of examples of hallucinations. I had a matter, and I can't reveal the details for confidentiality, but I was in a matter where we received a 15-page response to our position. And as I'm reading it, I'm like, yeah, this is not sounding like a human. It kind of does, but it kind of doesn't. So I started looking at a couple of the cases that were referenced, and straight away I was, oh, no, that's fake. It's not right. And it was just fake news. It was a hallucination. And all I had to do was just put it into our actual official research LexisNexis tool to identify that it was just a case that didn't even exist. Now, what did that do? Well, it kills credibility straight away. The whole thing's put into question, and you can leverage that to the advantage of your client that was fake. That's just one example, which wasn't even in relation to a court matter. But the courts are getting to the point they've had enough of the amount of hallucinations they are seeing, and they're starting to basically become stricter and stricter with lawyers to the point where it was in September last year where the first lawyer was actually demoted in their position, in that they were restricted from being able to act as a principal. They had to be supervised, and they got severely disciplined in Victoria for allowing hallucinations to appear in the works that they put in front of the court, because it generated so much work for the courts. The judge's associate had to trawl through cases to try and figure out, are these real or not, and they weren't. There was a immigration matter last year where there were 17 instances of incorrect citations generated by an AI tool. So I say this for the following reasons. It is a question of trust. If you can't trust fully the AI agent or the AI tool you are using, if it's still generating hallucinations, if it gives the wrong advice, you're responsible, definitely. And it's your responsibility, mine as a principal of a practice, and any business owner, to ensure that what they are producing is correct and doesn't expose them. If you don't check, you could go as far as, for example, if there's a case against you, you may not have the ability to be able to rely on your insurance because it was something that was able to be avoided by you. So I can see more and more cases where companies and firms with cybersecurity insurance or professional indemnity insurance, where insurers are saying, no, if you've actually gone stupidly and just relied on it without checking, hey, that's on you as well.
Yeah.
I can point out here as well that the courts have hit hard on lawyers and represented litigants in basically calling out that they will not be lenient on anyone that actually does incorrectly use AI. I can give you an example in Queensland that only has just hit the press at the end of March. And this is a case which involved an earth-moving business that was sued by their ex-employee, who was an earth mover himself, and that employee ended up, and it was MJ&D was the employer, and the individual went on AI and basically created all the submissions required to go to court, and he self-represented himself with the Fair Work Commission. The commissioner came back and said that the position put was so wrong, like there was so many errors in fact in the way that the submissions were made, and it was just wasting the court's time, essentially, was what he said. Now, that's a jurisdiction where if you employ me and you unfairly dismiss me because you've treated me so badly, I want to come after you, Hannah.
I knew I should have done the chicken thing.
I asked you for weeks to do the chicken thing, and then you terminated me.
Yeah, all I wanted to talk about was AI and Agentic AI and IP. Boring.
It was boring, I know, but, you wanted to do the 13 herbs. But where we ended up...
Tell me, I'll tell you later what the commissioner said to me about the chicken.
What ended up happening was that normally in that jurisdiction, if I took action against you, let's say I lost because my claim wasn't strong, then that's generally a cost-free jurisdiction, which means that you can't come after me for your legal costs because I took action against you. So you have a lot of individuals that go, you know what, I'm not going to employ a lawyer I'm actually going to use AI and I'm just going to do it myself. Well, for the first time, the actual deputy president who was overseeing this matter, his name is Lake, actually said, I would welcome an application by the respondents, being the employer, to put in a claim for costs on the basis of essentially the time that's been wasted on this matter. Now, it's very unusual for an actual deputy president overseeing a matter to actually say that that's how bad it was as well. And you're going to see more and more courts going down that path, I would say. So,
interesting.
Interesting cases.
So, where do we start? Everyone's, I think, on the AI bandwagon in some way, shape or form, and so they should be, because it is part of the future. Where else does that affect us in the land of intellectual property?
Yeah. Well, the first thing is that I should say I love AI as a tool. I'm actually one of the biggest proponents of it. Although I know a lot of people that would say, no, don't use it or be very careful. I think if you don't face into this, you're just going to be left behind.
100%. Yeah. I'm with you.
If you're not with it right now, you already are behind.
Yep.
Right? You've got to be with it. We use AI in our firm very carefully because of the high risk of hallucinations and incorrect use of it. So the biggest risk, if you look at, or one of the biggest risks if you look at AI and IP, is an area of IP is confidential information. And you can protect it through non-disclosure agreements and statements to the effect that information you're sharing is confidential. Think of the secret herbs and spices. That's confidential information and can be very, very valuable. So for us, our clients' information is confidential and is very, very valuable to our clients as well. And so we must maintain confidentiality of it. But if you use an open source AI tool, which means that any information you put in it is actually shared out in the ether across the internet, then you are very likely breaching your own client's confidentiality, and you expose yourself to a breach under the Privacy Act, or if you are an accountant, a lawyer, a doctor, also your own professional standards and obligations under your own codes. So that's the other big area of that intersect with IP, confidential information, and AI, where I see a massive risk. So for us as our firm, we limit the use of AI, and we're getting benefit from it, but not to the extent that it's stopping our lawyers from using their analytical minds, their thinking, doing proper research, doing proper assessments. We've limited ours more to administrative tasks to make our clients to make our team more efficient, and we've limited it to be very closed network just within our technology ecosystem to avoid it going out into the public realm as well. So that's the first thing I would say as a mechanism for minimizing your risk if you're using AI within your business, is have in place an acceptable use of AI policy. We've prepared these for clients, or we have one ourselves, which is what are the guardrails. I talked about guardrails before, and the government's actually issued some guardrails already in place, and I'll talk about AI and the law in a minute and how that works. But the government's already issued now 18 months, 2 years ago, some guardrails for the use of AI. I encourage anyone to read those because they're actually quite useful. But we've developed AI policies which set out how team members can use AI, how we disclose it to our clients, what can and can't be used, and when they do use it, what are the limitations to it, how to address the risks and manage those as well. So that's one area where it's an intersect with AI and IP law and general risks as well. Yeah.
What else is happening
Yeah.
in the courts? You pulled up a stack of papers
Yeah,
that you prepared before, Juan, and I'm curious about it because it's relevant and it's current.
Yes, definitely. So there's firstly, if I just take a step back, firstly, it's really important to understand that in Australia there is no AI law as such. In the EU, they've established an AI law. They've actually identified in the EU different categories of risks. And then in this act, they say that depending on which risk category you are in, the activity is either prohibited or not as well. So if I give you an example, here's one I prepared earlier. In the EU, if an item is or an activity is categorised as unacceptable risk, that's actually prohibited. And I'll list out some of the things. There's 8 of them, but I'll list out some of them. They've prohibited harmful AI-based manipulation and deception. So if you've actually gone out there and you're actually trying to deceive your audience, then that's prohibited. Exploitation of vulnerabilities, which AI can do very well.
Easily too, yeah.
Social scoring. So the use of AI and surveillance tools and social media data to start scoring, categorising individuals, that's been prohibited in the EU. Individual criminal offence risk assessment or prediction. So again, it's a bit like social scoring, but identifying if someone is a criminal or if you think they might do a criminal act as well. Now, it's really relevant to a case that happened in Australia, actually with Kmart. So I'm going to talk about that in a minute. It's really, really cool. And the other one here, and there's a heap of this, but untargeted scraping of the internet or CCTV material to create or expand facial recognition databases. So in the EU, they've actually gone as far as prohibiting these things. They also categorise other areas as high risk, and then there's different risks of category and there's different prohibitions and rules against that. Australia hasn't gone as far as that. They've gone only as far as saying, here are some guardrails which are more voluntary in nature, and we encourage businesses to actually go about in having these in place. And what the law instead has done is and where the Australian government has gone is to say the current legal landscape, is what will categorise whether AI use is illegal or not. And the main legislation there is some of the IP legislation that I've mentioned, including the Copyright Act. It's also the Privacy Act, which got strengthened last year, and some of those changes have already come into effect. Some are coming into effect at the end of this year as well. So there's been a delay with the implementation of some of those, but that was always known that some wouldn't come into effect till December this year. And then you've got Surveillance Acts and Telecommunications Acts. Now, you asked what are some of the biggest developments I'm seeing here and what are the courts saying. So if I go to facial recognition, because it's such an interesting topic, and I'll give a little anecdote. My parents, my son who's really techie, he installs a Google Home doorbell. So when he first installed it, because it's Google Home, it was connected to my parents' Google account, which has photos in it, and so it started to recognise photos and faces against names that were in my parents' photo directory. And my brother and I were very close.
This could go so many ways.
But my brother and I look really similar, right? And he's younger than me by about a year, but facially we're sometimes told that we look like twins, right? It's not that much. Later I'll show you a picture and maybe I'll let you put a picture of us both up as a laugh. And you can say who's better looking. He'll say it was him, right? But anyway, maybe he's right.
Depends whether you're going to be pressing me on the chicken thing or not. I mean, it could be you. Okay, Juan's clearly the better looking one.
He's already bribing me. And you know what this means? I'm building up this unfair dismissal claim right now, Hannah, as we talk.
God, and it's recorded. See, I'm full of mistakes.
I know.
Why can I just not keep my mouth shut?
Stop talking, Adam. Stop talking. So I press the doorbell and my mum answers and says, "Hey, Rick." And I said, "Hey, Mum." She goes, "Oh, that's not Rick. The facial recognition software got it wrong. Thought it was my brother." And sometimes when my brother presses the doorbell, he goes, "Hey, Juan, it's just got the two wrong." Now, the question is this. Who gave consent for my face to be recognised? I never gave consent. My brother never gave consent. Perhaps my parents gave consent when they accepted the terms and conditions of the use of this software and system. But for the users there, for the people coming to press the doorbell, none of them gave consent, yet their faces are being recognised. Kmart last year was prosecuted by the Privacy Commissioner for undertaking facial recognition in a number of its stores. And they were testing this system by tracking anyone that came in, because they identified that there was a significant amount of fraud going into returns of products. And what the commissioner said was, well, that was never disclosed properly to individuals, that they were being having their faces recognised and that this was being maintained. Now, what Kmart said was, well, hold on, under the Surveillance Act, we're doing this to protect our staff and make sure that, because it's leading to complaints and arguments and all this. But the Fair Work Commissioner said, well, actually, no, it's not Fair Work, sorry, the Privacy Commissioner said, no, you went over and beyond what you needed to be able to manage and identify this risk and reduce this risk. In fact, you breached the confidentiality and privacy of your patrons by doing this without their consent. There wasn't sufficient consent, and they stopped it. They actually prosecuted them. Now, turn then to a similar case that came through last year, which was for Bunnings. Bunnings did the same thing. And there's a bit of history to this one, but the short version of it is that Bunnings started scraping information and doing facial recognition because their staff were being abused. And what they wanted to do was actually stamp out criminal behaviour that put their staff at risk. And initially, the Privacy Commissioner won that case initially, but on appeal, the court found that it wasn't going overboard, that they had the right to do that because the primary purpose for which they were doing it was to protect the interests of their staff because of all the ways that staff were being attacked. So there are ways and exceptions around it. Here's the thing, though, that I would caution any business owner or anyone using AI in this way. every state has surveillance legislation, and that surveillance legislation says that you cannot, without the consent of a party, record a conversation, whether it's by video or it's audio or other means, without their consent. And in fact, if you do so without their consent, and there's some exceptions on way you can do this, which is for livelihood or health reasons, and there's some exceptions. But if you do it without consent, then that can be criminal. You can face up to 12 months imprisonment. Now, I am seeing that law broken almost every day, and I'll tell you how. I'll give you an example of a meeting I was in this week where two people joined, and each of them joined with their AI bot that was recording the conversation. Now, they didn't ask for permission to record the conversation. In fact, they just blazingly went in and they were very brazen in their approach. They just did it. And the problem with that, and I see it, like I said, every week, if not every day, that you've done so without consent, you're potentially in breach of the Surveillance Act. But there's other risks associated with that. And that is that when you actually, let's say I've in a meeting with you on Teams, and I may have invited 3 or 4 of your staff as well, but only you show up. So we record this conversation and we then start talking about your staff members. Oh, look, I've got a problem here. Now, this hasn't happened, just to be clear, so your team's not worried. But then my settings in my recording is that it goes out as a recording to everyone that was invited, not just the person that showed up.
Yep.
So all of a sudden they see a very confidential conversation that you and I are having. Not just that, it might be that that conversation was giving you legal advice which was privileged in nature, and all of a sudden it's being disclosed to someone that shouldn't have seen it, and we may have breached that privilege. And privilege is what we're able to offer our clients as a way of any conversations we have between us can't go anywhere else and can't be used against you generally unless it's waived. So if there were legal proceedings, the other side couldn't demand to see that because it's privileged. But if it's disclosed, even inadvertently, I may not have intended it to happen. I've just created for you a weakness in your legal position because I've waived privilege. And I've just created for myself a legal liability in breaching my obligations to you as your lawyer in that as well. And I see that all the time. The other day I was in a meeting where it was with, and again, I won't disclose their name, but they'll know who they are, and they're a senior person within one of the larger banks. And he started the meeting like this. And he said, I'm recording this in order to get your consent. Does everyone consent to me recording this conversation? It'll help us with taking notes, and then I'll share that with everyone. And everyone said yes. He goes, thank you. I'll continue the conversation. Excellent. Now, that seems a little bit over the top, but it only takes 30 seconds, but it completely changes your legal position from being in breach to being compliant, right? These are the things we're educating our staff. These are the things we're educating our clients on. And these are the sort of things that we're educating the public with through our articles and what we're getting out there. Does that help?
Yeah. And I'm curious, back on the Kmart thing.
Yeah.
Were the courts looking at it through the lens of, well, you needed consent from all of your patrons to do this? Or were they looking at it through the lens of, well, we can put some of that aside, we understand it's for the safety and protection of your staff, you needed to get the consent of only a portion of the people?
Yeah. The biggest lens they looked at it from was the information being collected reasonably necessary to protect either the staff or clients or to manage the risk. And the biggest thing that they found was that it was disproportionate. They went over the top. It wasn't information that was needed in order to be able to protect that interest.
I don't know if you have the answer to this question. How did they assess that was over the top?
They looked at firstly they asked, how did you disclose it? Which there was some notices, but they weren't that well seen. And so there's notification, there's consent to be, which there was no explicit consent for it. Now that's difficult because you're walking into a shop, you're not going to be ticking I consent to be.
Isn't it like a terms and conditions? If there's a big sign to say, hey, be warned, if you come in here, we use facial recognition. If you do bad things, we're going to come after you. And you walk in, you're accepting my terms and conditions.
And a lot of shops don't have that, yet they are doing facial recognition right now. So I predict you're going to see more and more retail outlets with that significant signage showing that as well. For that reason, in order to be able to at least show a level of consent when you've entered in. But they didn't have sufficient consent on that basis. So, and then what did the courts do? Well, the onus was on Kmart to be able to show that it was really the only means by which they could have done this. But the commissioner didn't accept that was the case. The commissioner said no, there was other ways you should have gone about collecting this information, not and other ways you could have mitigated this risk. And they didn't accept Kmart's position.
Again, you may not know the answer. Did the commissioner give examples of what those other methods were?
No, they not that I recall.
Yeah, okay.
I can check and see if they went as far as that, but not that I can recall.
Yeah, I'd find it pretty poor form to put on the table. Hey, Juan, that was over the top. You could have done it another way. Yeah. And I'm holding you responsible for it, but I'm not going to tell you what those other ways were.
Yeah. I mean, look, sometimes the courts do actually provide very helpful, because judges actually, if it's at the forefront or an area of developing law, then they want to be able to go as far as being able to give examples or supporting, because it's essentially creating law in that way. Yeah. So I don't recall if they went as far as that, but I can check for you. Yeah, that would be an interesting scenario if they did that.
And I do understand being a judge would be an incredibly difficult thing for the most part.
Yes, it is. I mean, I've never been a judge. I've been judged many times, but I'm not a judge. So yeah, it is incredibly difficult. But also anything that they say needs to be couched within the realm of what the legislation says, and if they go too far, then their decision
They've got handcuffs on to some degree, haven't they?
To a degree, in that the system we have in law is one of precedent, which is that law as it's accepted and different cases as they come up, you rely on those previous cases, and it might be that you elaborate on it, but you can't, if you just depart so far that it's completely opposite to the position that's been put in previous cases, then you could just lose that. That matter could be lost on appeal. The next judges may not agree with that as well. So, it isn't an easy job. I've never been asked to be a judge, and I don't know if I ever would want to be a judge anyway, and I respect them very much for that reason. But back to the risks with the Surveillance Act, I would say that is probably one of the bigger risks that we've seen that hasn't been properly understood. And it's as I see more and more tools being used, and it can be devices which have AI, just anything we've installed that has AI built into it. we really need to ask ourselves the question, which is, to what degree have I obtained the consent I need for using this device, or am I using it appropriately or not? So I'm not saying to anyone, don't use the bots that will record your conversations. I'm not saying to people, stop putting up surveillance cameras. I'm just saying, understand the risks in doing so and be prepared to minimise or at least work to minimise those, get the right consents and understand the law and the risks that you're taking on when you're using them.
What about dash cams?
Yeah, it's well, when you are recording in a public space like that and it's an incident, then that can be under one of the exceptions, which is that you're doing it for health and livelihood and so forth. So the dash cams, for that reason, have gone prolific and should be used. And so being out in a public space like that where you can say, well, I had to record it for my own health and livelihood, that would be an exception to that as well. It's when, if you got that dash cam and secretly recorded you and your staff having a conversation at a cafe, well, that would definitely be a breach. So with all these technologies, it's in the way you use it and the consents you get before you use them as well.
Awesome.
Yeah.
Is there anything else you want to add? I know we've gone off on a few tangents, but they've been interesting.
It's been fun, actually, yeah. So the other thing I would say is that the law, I can give you my opinion on this, is that the approach that Australia has taken is good on one hand. It's good because the law, the use of AI is evolving so much and developing so much that if you're not careful, if you implement laws, then they can become redundant very quickly, or using an AI bot, you find a way around it, right? So I like the approach the Australian government's taken in that it said, well, let's use our current legislative framework, the current laws in place, to regulate it as much as possible, and we'll watch and see how we go. And let's just have instead these voluntary guardrails and approaches to it. So on one hand, I think that is a good approach. But I do like that the EU has very clearly set out those things which you just must not do anymore. Now, some of those things are to a degree covered by the Privacy Act, and we've already seen that the Commission has become a lot more. This is the OAIC Commission has come out and been a lot stricter in respect of enforcing these rules, and that's why we saw the Kmart and Bunnings cases come up. So the Privacy Act's been strengthened for some of these things like surveillance and others. But I like the simplicity of the EU Act being able to say, hey, you've got to really do each business a risk assessment, and if it's high risk, you're prohibited from doing it. Others will disagree with me. They might say, well, who are you to say what's high risk or what isn't, right? But there are some things that are in the EU Act. For example, as I mentioned, AI-based manipulation and deception. Now, we do have misleading and deceptive conduct. You're not to undertake those. But what if it's between individuals and so forth? So I have some sympathy for that. I would love to see clear changes to be very clear in relation to ownership of IP for copyright under the Copyright Act. I think that gap right now is not an easy one to wrestle with right now. It's leading to this situation. There is, as I mentioned before, tons and tons, terabytes of IP being created by AI, which is potentially not protected, but more importantly, if it's not copyright, it's potentially a duplication of other work that's been put into these tools. And then not only could you potentially be breaching someone else's IP inadvertently, but secondly, is there a risk of a dumbing down of common knowledge or information out there because there's a duplicate and duplicative rubbish? If there's more and more hallucinations, then to what degree are we relying on misinformation more and more? And what it calls to me is that, again, back to my original point, use AI, get the most you can from it, but use it as a tool and be very cautious of it and check any of the outputs, because at the end of the day, the responsibility is on you. Each of the courts, and particularly the Supreme Courts and federal courts around the country, have put out practice notes and guidelines for the use of AI. And these are really, I think, quite helpful because they give you a sense of how the legal profession is being held accountable for how it's using AI, given all the hallucinations we've seen and the problems we're starting to see out there. And if I start with the Supreme Court practice note, this practice note, when it originally went out, was then accepted and used by a number of courts around the country. This is their, it's called Supreme Court Practice Note SC Gen 23. And here they actually call out the major risks and shortcomings of AI. They call it out as the scope for hallucinations, the dependence of generative AI on the quality and reach of underlying data sets, including the possibility that those data sets may include misinformation or selective or incomplete data. The scope for biased or inaccurate output, including by reason of the nature or limitations of the underlying data sets. The fact that any search requests via a chatbot or interactions or prompts within a Gen AI program may, unless disabled, be automatically added to the large language model database. So, disclosure of information. And then the lack of adequate safeguards to protect confidentiality is what they call out. And this is, again, to the point I just made a moment ago, the fact that data contained in a generative AI data set or database may have been obtained in breach of copyright. So it could be that some of this information is in breach. WA, as another example, the Supreme Court issued also some guidelines, said very similar things. They also called out jurisdiction issues. Generative AI tools may draw on jurisdictions with different substantive laws or procedural requirements. And incompleteness. AI-generated content may omit relevant arguments or issues or overlook essential tools.
I know lawyers who do that. What?
Not us. So here's the thing, though, and they all these say something to this effect. They say litigants and practitioners must ensure they understand the capabilities or limitations of AI, and that any information relied upon in this case in the Supreme Court must be verified by a human who takes legal responsibility for the contents of the document. And essentially saying that you'll be responsible for the accuracy of it. And if you get it wrong, it's on you. Some of these go as far as saying that if you are going to be relying on AI to prepare the basis of some documents, you have to actually seek leave of the court to do so. It's going as far as that. And there's some instance of that. For example, Supreme Court of New South Wales is saying is if you can't use AI, it shouldn't be used for generating a witness statement because it should be that witness's own recollection of it, right, of what happened. But if you're using it as a form of being able to gather or obtain some of the information, then some of that should be disclosed to all parties in the proceedings. Now, what does that do? As soon as you start disclosing or seeking leave of the court, it becomes its own little case in a case within a case, where then the court has to consider whether they accept your application for that to be used. Or the other side could say, well, we can't rely on this because how can you prove that, what was generated is correct or not? So you can see the quagmire here, like this whole area is evolving. The one thing I don't necessarily agree with is what is said in one of these overviews or guidelines, which is the third paragraph says the following: generative AI does not think or reason. Rather, it predicts word sequences based on training data. Generative AI tools rely entirely on the extent and quality of input data. Well, the accuracy does, but do you agree that it doesn't think or reason? And I think back to your original point right at the start with bots being able to independently start, or they are right now doing things. Is that thinking or reasoning? Can a machine do that? And this is where AI and agentic AI is challenging our true understanding of what it is to think, to reason, and then what is personage or not. I hope we don't get to a point where an AI bot has personality, legal personality. I think my own personal view. It's just my own personal view. I think that's going too far. I think we'll lose control. I think as an organisation, I think it's so dangerous if we're going down that path. Is that where we'll head? There's a lot of people that think that's where we're heading right now. I hope it's wrong.
Yeah, philosophically, it's so interesting to watch. And part of the argument now, again, a tangent, but I love tangents. There's a question out there that supposes that it could be that the bots, because they scrape a lot of data, and they've read philosophical texts already, are they actually thinking and reasoning of their own volition independently, or is it a tack on to all the stuff they've read, and they're going, oh, well, we're going down this path because that's what you do.
Yeah.
And where is the difference? Because you could also say a human being can philosophise because we've educated ourselves, same as the bot.
Yeah.
Oh, I read this book, Juan. Let's discuss this.
Yeah.
What is the difference between you and I doing it and an AI agent?
It leads to an even bigger conversation around, I guess, the differentiation between us as humans and animals, the ability to be able to exercise and use our free will. Because do animals have that versus what we have? Now, does an AI bot have free will? Well, I hope not. But as far as the thought process that an AI bot has, the fact that it might come up with a different answer now than if you asked it tomorrow because it will have different inputs, how much is that approximating that level of creativity, the ability to be able to make decisions and so forth? Look, it's a big topic. I know it's on podcasts left, right, and centre. I don't see it as having free will. I don't see it as being to that level as we do. I see it as an incredible tool that's that does make decisions. I don't think it's as far as what the Supreme Courts are saying, that it doesn't have the ability to make decisions. It does. It's doing it right now.
Yeah, 100%.
Every day.
Yep.
But I don't think it's as far as equivalent to human free will.
Not yet. And I don't know if it will. I don't know if it will, but I am absolutely not ruling it out.
Yeah.
Because if I rationalise and use my logic to say, well, where do we go next? What are we asking an agent to do?
Yeah.
And I look at an agent as almost like the lead. It could be my CEO.
Yeah.
And it's got a bunch of agents and people working for it.
Yes. And I've seen agents and AI tools that do that. They have different roles, and they have board meetings together, and then they come up with a recommendation for you based on them having had a board meeting.
So here's an interesting anecdote that leads me to believe the question of whether we give them personhood or not is closer perhaps than what we think. When an AI agent will tell a human being what to do. And that's happening today. There's a derogatory term that's been used in botland. We're known as the meat market.
Yeah, I've heard that.
Right? We are the meat market. So what the bot says is, well, we are doing, but we can't do something in physical reality. Oh, that's all right. Just pay the meat market to do it.
Yeah. That, to me, that is... to me, it's so dangerous.
Well, it's interesting. If you... It's potentially incredibly offensive.
Yeah.
And, again, if you zoom out and go, big macro view, it's not different to what we've done to other people. We've done to other animals. Like, are they just imitating our own behaviour?
Yeah.
And perhaps we don't like what we're seeing. And it's wow.
In some ways it is, because it is our data, it is our information that's being fed into this. It can be a mirror up to ourselves because as the courts have correctly said, our biases are built into it as well. And some of those are biases that are so prevalent that we don't even realise we have those biases, and they're all built in because of just the information that's contained. So, it is like a mirror to ourselves. Look, if it goes as far as that, then and as you say, there are cases where we've seen it go as far as that. And I talked about Claude and how the testing had done it. It actually had self-preservation. It had opted for self-preservation in deciding to actually blackmail the CEO. But is that independent thinking, or is that just the logical best way of protecting itself based on the subset of information it had? Anyway, I don't know the answer to that. All I know is that anyone who thinks that it is just a glorified Google search are kidding themselves. Yep. It is much more than that. And it has to be looked at, treated and understood in that. And you can't... But at the same time, you can't just give it free license to do whatever it wants, because then that will, right now, you are the person.
Yeah, and it's dangerous because if you give it open slather to do what it wants, it will do things you have never even dreamed of, and they may be potentially incredibly damaging. Yes.
And so therefore you, right now, if we talk about personage, you are the person. Like you will be the one responsible. It's your home on the line. It's your business on the line, and therefore protect yourself right now, because there's no get out of jail free in being able to say it was the agent that did it, not me. It just will not fly. The courts have said it won't fly, and the legislation said it won't fly. It's all
It's
on
you, isn't it?
It's you.
It's you.
It's you. It's you.
Ah, what a great conversation.
That was
and
awesome.
so interesting and philosophical for the future. We might do some more, and I might bring some chicken next time, just because it's on the table now.
You bring your 13 herbs, I'll bring mine, and we'll figure out which one tastes more like KFC. Let's
All
figure
right.
that out.
So, Jeremy, are we allowed to have food in the podcast studio?
I will soon find out.
Because I'm going to propose that the next time we catch up, I hope it won't be too far in the future,
Yeah.
we do actually bring chicken.
Oh, okay, let's do it. Let's have some fun.
It'd be interesting.
It'd be a good hook just to bring it in.
Yeah.
People will be wondering which one tastes better. Maybe we can do a bit of a survey.
Yeah.
Give it to the guys around the
Oh,
office.
yeah.
You know,
yeah, this is cool, man.
Yeah.
All right. Is that a deal?
Yeah, do it. Let's do it.
All right. Thanks as always, Juan. That was fun.
Thank you. I really enjoyed that, Hannah, and looking forward to it.
Yeah, me too.
Yeah.